Maybe just a dreamer, but I don't care. All I know my happiness is waiting somewhere, searching for that silver lining, horizons that I've never seen. Take just a moment and bring my. All right, I see people are jumping on. We'll give folks, as always, until a couple minutes after the hour to join us. We did have a large list of people sign up for today. Until then, enjoy the Commodores featuring Lionel Richie on lead vocal and their prescient song from 1977, Zoom. To know the taste of honey in my life. Well, I've shared so many things, and I All right. Hello. Thank you for joining. A good group this morning. I'm John Miller, senior attorney, founding attorney at Rock Solid Law and Title. And this is part of our series of webinars. And thank you for hanging with us. This one had to be rescheduled due to the hurricane, late season hurricane that we had recently. So Rock Solid Law and Title does three things. We close real estate professionally and on time. Pardon me. We represent entrepreneurial business owners. And we help keep American families, Florida families, strong through estate planning. And it's in this third area that we're going to speak this morning, and very specifically within estate planning, within trusts. The building block of an estate plan, the first trust is typically a revocable living trust. And then we're going to talk about what's called funding. Now, I'd like to start today by asking you a question. When you get ready to go on a trip, what is the first thing that you do? I'm going to guess one of the first things you do is get a suitcase out of the closet. And what's the next thing you do? You pack the suitcase. You put the things in the suitcase that you want to take with you on the trip. You're going to get this analogy by the end of the next 20, 25 minutes. Many of you probably already have. Let's look at life as the trip, and let's look at your trust as the suitcase, and let's look at your family as the people that are going on the trip with you. If you're a parent, or even if not a parent, likely some of the things you put in that suitcase are for other family members or other people, right? So, if I were all-time king of estate planning law, I would not have called this step in the process funding. I would have named it retitling. because when you think of funding something, people think of putting money into it, right? GoFundMe, for instance. Well, the funding process can be about money, but it can be about all sorts of other things, including real property and other valuable things that you want to be inside of your trust. Because the trust document itself is like that empty suitcase we talked about that you took out of the closet when you were about to go on the trip. And how useless would it be? How useless would it be to take an empty suitcase on your trip rather than packing the things that you need on that journey? So I want you to remember to think of your trust or a living trust as the suitcase. Folks, I regularly have people come to see me who have had a trust for many, many years, sometimes decades, and they bring me a really pretty notebook and they say to me, "What have I got here?" And I review their estate plan for many reasons. But then when we talk again about it, I say, "What have you funded or transferred into your trust?" And they often look at me with a very quizzical expression because, and I'll explain why in a minute, many, if not most, estate planning attorneys create the documents that their clients need, but utterly fail to help the clients do what may be the most important step, and that is putting their assets as appropriate into the trust. Now, just really, really quickly, what does a trust do? At the very most basic level, it keeps you away from the unnecessary cost, expense, and delay of probate. Folks are surprised all the time when I say that every last will and testament is specifically designed to go to court. In order to have the wishes contained in a last will and testament carried out, a probate proceeding is necessary, meaning that a lawsuit has to be opened. Those lawsuits don't get opened and closed overnight. In fact, a fast one is 6 months. And if there's any dispute, it can be years and years and years. I've seen them 5+ years. I would say regularly a year or two. Very few of them are opened and closed within the same 1-year period. They are expensive. The reasonable attorney's fee for the basic services is by statute 3% of the value of the estate. Now, when folks have accumulated several $100,000, $500,000, and certainly more than that, we start looking at a trust rather than a will. Because a trust, if all of the assets are properly funded into the trust, does not go to court. There's no lawsuit. Nobody has to deal with a judge. And all of your life's details are not down there in the county court records for people to perhaps be able to see. So why don't you want probate? You don't want it because it's a pain and it affects your legacy. Why did mom or dad leave it behind for me to have to deal with this? Right? Becomes an enduring part of your legacy and never in a positive way. I have had a few people say, "Oh yeah, we did a probate and it was easy." And I just congratulate them because they are totally the exception to the rule. It's also expensive. So whatever you don't spend, it doesn't get to where you want it to go. Some percentage of it, probably 10, sometimes 30, is lost along the way to attorney's fees, accountants' fees, appraisers' fees, all sorts of other professionals who may need to get involved in the process, including creditors And in this day and age, unfortunately, fake creditors, they come out of the woodwork to try to get a piece of that estate. Also, in the instance where an heir really needs to get access to the money, there will be a delay. If it goes to court, there will not be a delay if there is a trust. So that gives you a little bit of the why is it important to have a trust and fund the trust. It is useless to have a trust without funding it. Why then do a lot of law firms not help their clients fund the trust? Here's the ugly truth, folks. There's a lot of money to be made in probate. The adult children of a decedent typically go back to the same lawyer who drafted the documents. And if the assets are not properly within the estate, a probate is filed, and that law firm makes a lot of money. I don't believe in this. I don't think it's right. I think when you come and do a plan with us and it includes a trust, it ought to be effective and it ought to skip probate just like we planned. Therefore, Rock Solid Law helps our clients retitle or fund their trust before we let go of them. You have to cooperate. We need the client's help. I can't go to the bank and sign your name, right? Neither should I be able to. But I will coordinate with your financial planner, your stockbroker, your banker, and anybody else in your life to make sure that all of your assets are properly funded or retitled into your trust so that your plan is effective. So this is like putting the clothes you need, the toiletries you need, and everything else you need for that trip we talked about at the beginning into the suitcase. So the suitcase actually serves a purpose on your trip. A trust serves a purpose on your trip through life and after your life. It is the opportunity to set your beloved people, your heirs, your children, your whoever it is you care about, maybe it's a charity, up for success by getting those assets to them how you want and when you want, right? So the trust will avoid probate for all of the assets you put in the trust. The process of putting those assets into the trust is known as funding. Again, if I were king of estate planning law, I would have called it just simply retitling. That makes more sense to me. So what are the steps? So we've gone through the whole estate planning process. We've had a consultation. We've decided what's right for the client. And if that includes a trust, we will create the trust. The client will review the trust. The client will then come in and sign the trust along with all the other documents. That's great. So at that point in time, we do have a functional trust because along with the trust, we've created what is known as a pour over will. So God forbid it were ever to happen, immediately after signing, a client would die before they had the opportunity to fund. The pour over will could be filed with the court and would effectively put all of the assets into the trust. But you don't want to rely on that because there you go right back at court, right? So what does a trust do? You choose who your successor trustee is. Who's the person that you trust to take care of all of those assets for you and to follow the rules that you've set out, right? So you might say, for instance, in your trust, oh gosh, if I die before my kids are 18, I sure don't want them to get their hands on millions of dollars right away, because why? Statistics show they're going to blow it. And then they're going to have a life of remorse and regret because you set them up with all that, but they frittered it away, choose your own term, and didn't have the benefit it fit for their life. So what might you do instead? You might phase in when they're going to get those assets. And there are good reasons for that. They're outside the scope of this particular webinar. But you might give them something in their 20s and something in their 30s. And I've had clients that go out to the 50s. And I've actually had a client that waited till 70, which seems like a long time to me. But the idea is to set up the retirement for their children. And if their children don't make it to that age, it would go to their grandchildren. So after the documents are signed, we have a member of our team who is specifically trained to deal with the different assets that need to be funded in the trust. As part of the creation of that trust, we are going to create a deed which moves the homestead into the trust. We don't lose any of the wonderful Florida homestead protections by doing that. We would never lose those homestead protections. If you have other property, depending on how it's held, real property, we would move that into the trust. We assign the ownership of all of your stuff into the trust. All of those things in your house are now owned by your trust. Why? So your successor trustee has the right to dole them out as you see fit. And you can make the rules on how that happens. Have a lottery, let them choose one at a time, whatever, or just let your trustee hand it out. That's fine. Then we need to look at investment accounts, qualified retirement accounts, bank accounts, any other way that people hold wealth. That 57 convertible Chevrolet Corvette, let's make it a Corvette. Yeah, we're going to title that into the trust because we don't want that to have to go to court because the value of that will be diminished by just going through that probate process, right? So we're going to look at what you have, and it's different for everybody. And we know the rules, right? So we get asked all the time, what about my 401k? What about my IRA? Right. There's a federal law that says that needs to stay in your ownership. And if you're married, the first person you leave it to is your spouse. Why? Because there's still a little bit, 10 years of a stretch left to help us with tax issues before required minimum distributions. And often when the children inherit, they're in the ages that are their highest earnings. So they're going to be in the highest tax bracket. So we want to try to help not allow those things to be inherited at the time that they will do the most damage to the taxes, right? We're going to look at those things too. So not every account that you have will immediately be renamed, retitled, or funded under the name of your trust, but a lot of them will. Your checkings and savings accounts certainly can. And we're going to instruct you through the rest of your life that when you do things financially, make sure that they get titled into your trust. And we're giving you something called a certification of trust specifically for that purpose, right? But don't let any of this overwhelm you because we're going to be there and walk that path with you if you will assist us in doing it. And we do have clients that for some reason get to that point in the process and ghost us, and we can't help them. And that's too bad because don't do that, right? We need to get all of the assets into the trust, a list of those assets with the trust so that your successor trustee knows what they're doing, okay? So that's called the funding process. Just to belabor the point, when I am consulting with people, I say that the trust is a bowl, a receptacle of some kind, a basket. You can make it anything you want it to be in your mind, but that is an empty bowl, just like our empty suitcase, right? And you've got to put things into the bowl to make them effective, all right? So we go through the whole process till we have a trust and we've recited some consideration like $10 or $20 or something to breathe life into that trust. So it's up, it's alive, and it's going, but it's hungry. And that bowl is empty. And we need to take all of your stuff, all of your, not your stuff, we already put your stuff in, all of your accounts, all of the things that you own by a title somehow, and retitle them into the trust. There, you still maintain complete and utter control if you've named yourself trustee, which is almost a certainty in the process, during your lifetime and the lifetime of your survivor. And then when you're gone, your successor trustee, everything we've put in this bowl, they now have control of. And they have control of it according to the rules you have written inside of your trust. And I'm fond of saying, if it's not illegal and you can come up with it, I can write it down for you. We can make those rules inside the trust. We can make sure that somebody who's got an addiction problem doesn't inherit that money. right? You don't want to help them go get more of the thing that they need to kick. We want to put in there that they can get rehabilitation. And once they've completed that and shown that they are mature and able to manage what you've left for them, your trustee can give it to them. Your trustee can dole that money out or those accounts out in any way that you require, but only the things that are inside of the trust. And that's why we want to get things inside the trust and not have a probate. The probate king law firms who are banking on not only you're paying them to create this trust, but your kids paying them again to take the account, to take everything you've got or whatever you don't put in the trust into the basket, into the suitcase, into the trust. They're going to get paid again at court. Will I help a family that I didn't get to plan with through probate? You bet I will. Will I help a family go get that account that somebody opened after we dealt with them and get it into the trust? Absolutely. But I'm going to do everything I can for our firm to help our clients avoid going through probate. All right. So there is a higher cost of creating a trust than there is a last will and testament. But that cost is thousands and thousands, and in many cases, tens, and in some even hundreds of thousands less than taking those same assets through probate. It's on a case-by-case basis. I've had people that don't have a lot of assets absolutely want to do a trust because it's the easy button for their kids, their heirs. And then I've had people who've said, what do I care? I'll be dead, right? They didn't earn this. Let them go through probate. Let them earn it that way. And whatever's left over, they can have it. Most families don't believe in that. And me, I believe that the Floridian American family is really the core of our culture, and making those families strong through the generations is what we believe in doing here. And by creating trusts, properly writing the rules inside those trusts, and properly funding those trusts, we carry out that part of our quest. So there is, I forgot to say it earlier, a question and answer and a chat button. If anybody has a specific question you want to ask, I'll be rapid in a few minutes. So I will give you the opportunity to put that question in there and I can answer it. I always like to say also, if your question is very fact specific and has to do with your personal information that you might not want to share on this Zoom or on the recording, which will be at our website, feel free to submit that question to us at questions, that's plural, at rocksolidlaw.com, or call us at 904-241-1113. Right? So sometimes people say, well, why is your trust package higher than that one of that law firm down the street? And that's because as part of every plan, we include the funding. We are going to help you to breathe life into your trust and make it effective for your heirs and not leave them to have to go see the judge after you're gone. Okay. So make sure if you're just making a decision on cost, which there are reasons that I don't think that's the best idea either. I mean, we're consistent with the other quality lawyers around, of course. If you're just making a decision on cost, make sure you're comparing apples to apples. And if that lawyer is not quoting you to fund your trust, then you now know why not, right? So what typically happens is in the final package, the lawyer inserts a sheet of paper that says, now go fund your trust. And it may have some instructions on contacting your bank and getting them to change things over, blah, blah, blah. But we all know that over 90% of people that get that instruction don't do it. Why? Because they've accomplished a big thing. They've done an adult thing. They've got their estate plan complete, and most people are like, oh, yeah, I'm done. But the bold truth is they're not done. You're not done until you get your assets into that trust. All right, I see I've got a couple questions. Yay. So let me say this before I do the questions. There are a lot of you here today. So for anyone who has not yet done their estate plan, and by the way, no stones cast here, that's over 70% of Americans either have no estate plan at all or a really old or an ineffective one. So don't worry about embarrassment. Lots of people start the consultation with, we did this when the kids were born, or we've been meaning to get around to this for 25 years. We just haven't. That's fine. We're going to take care of it. We're going to get you done. But don't do it without properly funding your trust, retitling those assets. So any of you who have not had the opportunity to talk about this, if you call 904-241-1113, that's our firm. Just let the ladies know you attended this webinar and that I said that we will waive the consultation fee and we'll sit and talk to you about your future, your family's future, and your plan without charge. Okay. I'll probably remember to say that again at the end, but in case anybody dropped off during question and answer time, I wanted to say that to you. All right. Oh, good questions already. I'm seeing. Good morning, Marcy. Hope you don't mind me using your name. If anybody's asked a question, doesn't want me to use your name, say so quick on the question and answer. So you put cars into the trust, question mark. Yeah. So cars are a little bit special because at this point in time, the DMV will transfer title with a death certificate to a family member, particularly if you have a will. So what I advise people is vehicles should be put into the trust to make things easy for your successor trustee. However, if you're somebody that trades in a car every 3 or 4 years, I think it's fine to leave the current one out and not have the hassle of transferring it with the DMV, but to make sure and put your next one in there. Last night at Halloween, I saw somebody had a DeLorean. If you've got a Lamborghini, a particularly valuable car, a collectible car, 57 Chevy's my favorite, a 66 Mustang convertible cherry red. Yeah, I'm going to ask you to title those into your trust because those are valuable assets. And we want to make it easy on your successor trustee by putting those into trust. Next question. Good morning, Adam. Does a debt associated with assets impact the ability to move it to the trust, not to a revocable trust? And you may be specifically thinking of a mortgage. Specifically, there is a statute that permits us to transfer homes into the trust when there's an outstanding mortgage, if that trust is revocable. Other assets, we need to examine the debt and the instrument which creates the security. In the case I mentioned, that's a mortgage, but it could be a collateralization or security agreement, and we'd need to review that to make sure what the rules are associated with that. So, and I will go a little outside of my scope, and that is that if it's an irrevocable trust and there's debt associated, we need to look at that fact pattern as well, because it's very probable that could cause the due on sale clause to be invoked. So we would not want to take a risk there. That's similar to putting it in an LLC for asset protection, say, for instance, for a investment or rental property that has a mortgage against it. Let's see. Good morning, John. Okay, I touched on cars. Boats would be about the same thing, particularly you know, not my John boat with the 3 horsepower motor on it, but certainly a yacht. You're going to want to put that into your trust. Thank you for the second question that you asked as well. If you go to rocksolidlaw.com, I think it's videos, but it might be webinars. I'm certain that there is a webinar on irrevocable trusts, and you specifically asked irrevocable trusts to control use of larger funds runs through several generations as a legacy trust? Yes. You know what? I love that subject. I'm block copying your request. I am going to get my team to include that on one of the future webinars that we do. There, I took care of queuing that up. I love that subject and will be delighted to teach irrevocable trust in that regard again, probably in the first quarter of next year. Next question, can my privately held business, hey, by the way, you guys are great. Lots of good questions this morning. Be put into the trust if I own less than 100%? Does that affect the move to the trust? Absolutely. The answer is you should move your interest in your company into the trust, but it's dependent on your partnership agreement, your shareholder agreement, your operating agreement, if that is permissible, particularly if you're less than 100% owner, which is exactly what you asked. So we typically move ownership of a closely held business into the trust. But there are circumstances where we would not do that. Yeah, I think I hit that one. Good. Hi, Trish. So glad to see you. I typically, regular vehicles is the nature of her question. You can fund that right away if you wish to do so. If you're going to get a new car soon, I would just wait and title the next car in the trust. But if you're like me and you keep cars for a good long time and drive them to death, well, you may want to go ahead and do that now. How does insurance, home, car, life work with the trust? So, if once you put your home into the revocable trust, you want to notify your insurance agent to make sure that coverage remains on that. Same answer for your car. Still stays in effect, should not affect your premium at all. Life insurance, we typically, it's a client by client analysis response, but typically we're going to have the life insurance go through the trust. Why? A couple of good reasons. One, then that money is subject to whatever rules you've written for the trust. And two, equalization. If you have several kids and a spouse and you don't know what the future holds, you don't want somebody to inherit that money, because then it's not subject to the rules you've written, and one person could get an unequal distribution as compared to the others. All right, that's with life insurance. Remember, my team and I are going to be there for that part of the journey, looking at your individual assets to help you with that. So who is the successor trustee? What kind of person are you wanting? Great question. As the term trust goes, it's got to be somebody you trust. It should really be somebody that will have the very best interest of your beneficiaries in mind. And I would say somebody with some financial literacy. There are private individuals that will undertake this. There are divisions of banks that will undertake it. Most people we work with have someone in the family that they trust and that they believe would be able to manage that duty for them. By the way, as part of our services, I am happy to meet with or Zoom with your successor trustee and to let them know what their duties and obligations will be in the future. By the way, since it's a revocable trust, you can always change your mind and choose someone else. The next question, I got two more, and I know I'm going a little over, but I think these are interesting questions, so we're going to try to hit it. Okay, that's a follow-up to the question I was on. Do you have a beneficiary B1? It depends. be a successor trustee. In some cases, that's okay. In many cases, it's not. It's the old fox guarding the hen house. So it really depends on what's in the trust and who the people are and what your relationship is with them. So it's possible that a beneficiary can be a successor trustee depending on who the trust is benefiting, right? The next question is, will a trust have an impact on Medicare nursing home care in later years? A revocable living trust will not. There are other types of trust which are specifically for that purpose. My firm does not specialize in Medicare, but I have a good referral for that. All right, let's see. I believe I'm down to my last question. You guys are great. Once a home is retitled into the trust, can I get rid of home title lock? Is the deed then protected from this type of fraud? Well, I've never had that question before. I believe that your title insurance policy protects you from that type of fraud. And I guess it would depend on the terms of your home title lock. I know they are big advertisers and have become a more popular product over recent years. I don't know that. See, the wild deed is what you're worried about, right? Somebody signing a deed over your name. They could just as easily sign it over your name as trustee. Perhaps it would be more difficult for them to get that type of deed correct. They certainly wouldn't have the certification of trust to present. So I would say that you are better protected once it gets in the trust, and it would be a personal decision whether you want to get rid of the home title lock product. Wow, great questions this morning, guys. You were just the type of people I would love to consult with. Those of you that I haven't had the opportunity to meet, you are very, very welcome to make an appointment with us and make sure that we go over your fact situation and, if appropriate, work together to protect you and your family. So this has been a great one. It will be available if you have friends or family that should view it online at rocksolidlaw.com in the coming days. And remember, if you have a question that you would like answered, that's questions at rocksolidlaw.com. Our phone number is 904-241-1113. And for joining me this morning, you are entitled to a free or a fee waived consultation. I do see several clients on in the group today. If you guys have someone you'd like to refer, make sure that we know that it comes from you and that you were on this, and I'll be glad to waive the fee for them as well. So glad to spend this time with you this morning. I thought this was going to be a short one, but your great questions made it not so short. We will be back again with you. Gosh, it's November, so later this month. Usually I say next month. And I would love for you to join us for our next in this series of webinars. Thanks for spending the time with me. I'm John Miller, founding attorney, Rock Solid Law and Title. Have a wonderful weekend.